Welcome to another in the series of NJAPM webinars. Today, we're having an interview of Bob Margulies by Laura Kaster, and the topic is Decision-Making and Self-Determination, How Manipulative is Mediation? Bob Margulies is an active litigation lawyer, mediator, arbitrator, and instructor in ADR and negotiation at the New Jersey Institute for Continuing Legal Education and Rutgers Law School. He's the founder of the Garibaldi Inn of Courts, and he has been recognized with the J. Dell Award in 2011 and the Bosky Award in 2003, and Nichols Distinguished Service Award in 2006. Laura Kaster is the 2018 recipient of the Richard J. Dell Award for ADR Excellence from the Justice Marie L. Garibaldi Inn of Court and the 2014 New Jersey State Bar Association's Bosky Award for the ADR Practitioner of the Year. She is the CDR accredited and an IMI certified mediator. She's a master mediator for the AAA. So, before I turn it over to Laura, I just want to tell you who may not have seen one of our webinars before, if you go to the bottom of your Zoom screen with your mouse, you will see a Q&A function. If you push on that, you'll be able to ask a question in a written form, and then Laura will either during the presentation or at the end answer or have Bob answer your questions. So with that, I'm going to turn it over to Laura.
Thank you so much, Carl. We're really both pleased to be here with the NJAPM webcast, which is the first one we've attended, and I'm very happy to be with Bob Margulies today on this topic. Bob, as Carl said, is a preeminent New Jersey mediator and instructor and a mentor to many New Jersey mediators. He will start with a little presentation of a few minutes, and then we will have a discussion back and forth about this topic. And on your screen, there's, as Carl said, a Q&A tab. Please write your questions there, and I will either incorporate them into my interview or we'll address them at the end. Thank you, and over to you, Bob.
Thank you so much, Laura, and welcome everyone. What I want to do is I want to start out in talking about this subject and starting in the beginning and how New Jersey views mediation. But before doing that, what I love to quote is a very famous negotiator. You've all heard of him, Abraham Lincoln. And in his 1850 law lecture notes, I think he synthesized what it is that we do and why we do it. Persuade your neighbors to compromise whenever you can. Point out to them the nominal winner is often a real loser in fees, expenses, and waste of time. As a peacemaker, the lawyer has a superior opportunity of being a good person. And since everybody as a mediator is not a lawyer, I think whatever you do, you have a superior opportunity of being a good person. And I'll talk in a few moments about why being a good person may be one of the issues and one of the problems. So where do we start? Well, New Jersey, at least in the court system, has identified mediation as a facilitated process. In fact, in Rule 1:40-2, we don't call it mediation. We say facilitated process, which includes mediation, is a process by which a neutral third party facilitates communication between parties in an effort to promote settlement without imposition of the facilitator's own judgment regarding the issues in dispute. One of the issues and problems, if you're going to be a facilitator and you're going to be facilitating another's discussion, and this is not transformational in any way, how manipulative do you, depending upon your background and experience, especially if you're a lawyer, do you influence the parties? So self-determination. One of the pillars of mediation is this concept of self-determination. It's a silly idea that people ought to be able to make their own decisions, as opposed to one being imposed upon them by, for instance, an arbitrator or a judge. And we have further rules that apply, would seem to apply by reading them to the court system that relates to standards of conduct for mediators. However, since these essentially same rules have been adopted by NJAPM in 2007, by the American Arbitration Association, the American Bar Association, and the Association for Conflict Resolution, first in '94, and then again in 2005, and in New Jersey in 2000, the first principle is the principle of self-determination. So what does it mean? It means that a mediator shall, that's mandatory, proceed with the understanding that mediation is based on the fundamental principle of self-determination by the parties. It requires that the mediation process rely on the ability of the parties, not the mediator, but the parties, to reach a voluntary agreement without coercion. And this standard, which I suggest to you, even though it's a court standard, applies throughout mediation as a preferred method of mediation in New Jersey, indicates that the mediator in a mandatory manner shall inform the parties that it's consensual in nature, that you're impartial, anybody can withdraw at any time, and the mediator may not impose or force a settlement, no matter how good we think it is. The primary role is to promote a voluntary resolution, allowing the parties the opportunity to consider the options for settlement. And the third part is, in the event the mediator, the mediator, if he or she so determined, should make the parties aware that they might want to talk to somebody else, another professional, before they make their decision. Now, so self-determination is this pillar, this silly idea, as I said, that people should be able to make their own decisions. Let me look at the role of the mediator for a moment. This neutral that brings all of their collective experience, all of their prejudices, all of their particular background into the mediation process. Now, I'm going to suggest to those of you who are women that notwithstanding the bravado of men, you may have scientifically a better shot at being a better mediator than the men. That may sound controversial, but a Dr. Lou-Anne Bresendine wrote a book several years ago, Man versus Woman. The Female Brain, which talks about the difference between man versus woman. And she scientifically suggests that when the fetus is bathed in the womb by either testosterone or the female hormone, different connections in the brain are either destroyed or maintained. And as a result of that, men and women act differently. And her proof that men are much more combative, much more interactive, and approach problems differently than women, who have a tendency to be much more rational in making a decision, is that men use 6,000 or 7,000 words a day, and women 20,000 words a day. So women, I think, may have literally the leg up in this profession. One of the things that we're doing today, and I suggest that you look at, if you go online and put in neuroscience and mediation, you may be surprised to find an awful lot of information, because science is now being applied to mediation. And in a very generic way, the concept is that we have a primordial brain and we have a rational brain. And that to the extent that our emotional sense is so heightened that we cannot actually make a rational decision. So one of the things that we have to be concerned about in self-determination is if you have self-determination and if you're making an emotional decision, or if that's influencing your decision, to what extent is that real self-determination? And I suggest that you start thinking about this and looking at this, because it is something that is affecting the way mediators can best perform their services. Now, we know that mediators take the position as a facilitative mediator, not an evaluative mediator, but we take the position in that regard that we are not imposing in any way our judgment, our thought, our rationale on the decision-making process. And one of the things we're going to talk about, and I question, is that really so? When we get started, I'm going to ask Laura because to talk about the Stanley Riser out of Stanford and the whole idea of how you exercise judgment, but I'm not quite ready yet. One of the concerns that I always have, especially dealing with lawyers, but dealing with all mediators, is that we all have a sense, you almost as a mediator, when you help parties resolve a problem, you feel good about it. You get a little bit of a, whether it's like a runner's high must be, the endorphins must flow a little, and it feels good to help people. I am concerned about that because to the extent that you are a do-gooder and you want to help, I suggest you follow the Hippocratic Oath, do no harm. I'm much more concerned about you doing harm to the negotiation, and I see it on a regular basis because not only do I act as a mediator, but I also represent clients in mediation, and I see it on too regular a basis where people want to do good, they want to help, so they have a tendency, whether it's the thumb on the scale or to skew the discussion, and I think we have to be very careful in that regard. And I try assiduously, especially when I'm a mediator, to do no harm. And if someone's going to do something stupid, at least in my experience would be stupid, for instance, they get tired and they suggest that we're just going to give them the bottom line, whatever that is, and they can take it or leave it, we're going home. I try to have a discussion as to whether that's in their best interest and how do they think the other side will react, and talk about how negotiation really works. So if this is self-determination and you are a neutral, I want you to think about how you can be helpful and be facilitative, and this not be transformative in any particular, even though it may be transformative, but how you are going to help and to what extent you can make suggestions, to what extent you can help parties create options, to what extent you can advise people regarding what the law may be or not be, whether it's important or not, and to what extent you can actively participate, even as a devil's advocate, in the discussions that you have in a caucus session. One of the other issues that I think that we have to be concerned about is an issue that actually in the last election was talked about a little. It's called implicit bias. What are all the internal implicit biases that we have that we bring to the table that we're not aware of? That's something also you should Google and read a little about, because we have to be self-aware. It's sort of like know thyself. And we have to be self-aware especially in the diverse communities that we work. We happen to be sitting here in New Jersey, one of the most diverse communities in the country. So we have to be very aware of that. So with that, actually, Laura, before we start question and answer, tell us a little bit about how good we are, at least lawyers are, at exercising judgment?
Well, we know we're pretty bad, actually. There were two major, very large case studies, one on the West Coast and one on the East Coast, each of 2,000 cases done by Randy Kaiser and a bunch of people from Wharton School. And they looked at cases, 2,000 cases in each case, where a settlement had been offered and rejected, and the case went to trial. And they called it decision error when the plaintiff got the same amount or less after trial, or the defendant paid the same amount or more after trial. And the ratios are kind of astounding. They found that there was decision error in 61% of the cases for plaintiffs and 24% for defendants. And I don't consider that 24% a good number, but it's certainly better. However, the average mistake cost defendants on the order of 20 times more than it costs plaintiffs. So we know that lawyers and their clients together engage in a kind of false assessment of their cases on a very routine basis. And I think this does come to very much what Bob was talking. Implicit bias is one species only of what I call mind bugs, our unconscious minds giving us shortcuts to solution. And one of those mind bugs is the sunk cost bias. So you'll hear every time you mediate, I think, I've heard it every time I mediate, is, well, I would have thought about that at the beginning, but they've been such idiots in connection with discovery, or I've spent so much money from the beginning that I can't think of the value of the case as what I would have thought of it at the beginning. That's just patently economically wrong. I actually said that to someone in a mediation recently, and they got off that tack because I said that's a cognitive bias. You're mistaking the value of the case when you think about that. The value is only the value going forward. So that, and combined with groupthink, which is the Irving Janis sort of analysis of why there's such a horrible mistake got made in the Cuban missile crisis and the invasion of Cuba. So I totally agree with what Bob said. We need to help people get past some of their biases, and it's risky. It's a risky business to do that. You do have a very powerful influence. I think most of the mediators' influences rapport. What do you think about that, Bob?
Well, I wanted you to add one more thing because I think it's interesting. You used to be head of litigation at AT&T, small company we've all heard of. And I always like you to describe when you had a case come in that appeared to be a complete winner, how you evaluated it at the start with respect to mediation.
Well, I think Bob is referring to, and this is true. If I really thought we had a real great winner for the client, I would say you have a maximum of 80% chance of success. And that's because you either have a jury trial or you have a judge, and you don't know what's going to happen with that 20% chance, even in the best of cases. Because you can have a runaway jury, you can have a judge who makes crazy decisions. So, or an arbitrator for that matter, who makes a decision that's very different from what you're thinking. So I say that to people in mediation when they tell me they have a slam dunk case. I start out and I say, well, so if I would have to advise my client that was 80%, they usually say yes. They don't actually mean they have a slam dunk case. That's a posture, but I don't argue with them. And then I say, okay, so you've been litigating for 5 years. Somebody's going to appeal, right? And they say, yeah, okay, that's fair. Somebody's going to appeal. I said, so let's assume you have an 80% chance of success on appeal. They say, yeah, okay. And then I say, so you have a 64%, that's the math, a 64% chance of success between here and the $350,000 it's going to take to actually try the case. And the client falls off the chair because 64% sounds too close to 50% to be a slam dunk. So maybe that was what you were talking about, Bob.
Yes, yes, Laura. So if we have these negotiators, and Laura's talking about these studies were done with actual trial lawyers. These weren't wannabes. These were people actually tried these cases, which is sort of interesting. They were all kinds of cases. How does that affect self-determination of the client? Who are we there to serve? Who's there in the process? We know intellectually that clients are supposed to make decisions. We also know that their advisors, and particularly their lawyers, influence their decision and may have a permissible conflict of interest in the sense that their compensation may be reliant upon whatever the client decides to do. So that power balance, that negotiation that goes on between all of us, who do I mean? The various mediations that we're having between the various clients, between the clients and the lawyers. It may be between the lawyers and the lawyers, or the lawyers and the clients. It's something that we have to figure out how to manage.
So I've asked you this before, but in my own mediation, I have found very often that I'm trying to help the lawyer communicate to the client some bad news. That they have not, they have either tried to communicate and it hasn't been heard, or they haven't been willing to communicate fully because it's too damaging to the relationship. Is that something you have found as well?
Yeah, well, the way I look at it, Laura, is I look at the negotiation and a mediation often as the readjustment of expectation. Problem being, everybody wants to readjust the other side's expectation. They don't want their expectation readjusted. So a part of this, through utilization of these reality techniques, I think the Harvard people call it objective reality. In other words, what are some of the standards that we can look at? What are some of the real things that we can look at to help people readjust their expectation? And that's usually different from their negotiating style, because everybody comes in with a different negotiating style. So it's a balance. It's almost an education. And one thing that often happens, we have to be very careful of. Oftentimes, we as mediators, we are seeking trust of the parties. That puts us in a very powerful and dangerous position, because once they trust us, they may or may not trust their lawyers. They may or may not trust themselves. And so to the extent that they are trusting us and we are making suggestions, even if it's only after exhausting their options, helping them create options, to what extent is that really being somewhat manipulative, and is that a good or a bad thing?
Well, Bob, talking about making suggestions, one of the things about facilitative mediation, the commitment to it, is commitment with respect to the process. So we are the guardians of the process in some way in the mediation, and you certainly want to make people feel secure that you know what you're doing in the process. But how do you deal with process issues so that the parties can also be, if they so desire, the controller of the process?
Well, I think one thing that I like to do is empower the parties and tell them how much they are, as opposed to a process where a judge or an arbitrator makes a decision, how they are really in control of their destiny here in this process. And I try not to take over and become, other than providing, it's like the chef. I'm helping put the ingredients in, I'm helping cook it, I'm knowing the right temperatures, and I'm knowing the right ingredients and the right spices, but they're the ones that are going to enjoy this meal, and I'm not going to even eat the meal. They're going to enjoy the meal and move forward. So I think it's doing it. And you notice what I did here is something that I think is important in the way we communicate. It turns out that although we think that we communicate in straightforward, declarative kinds of dissemination of information, much of the way we communicate is through example, is through metaphor, is by creating almost a visual picture of how someone is going to react under a certain set of circumstances. And I think to the extent, for instance, when I describe on conflict of interest or decision-making and self-determination, I don't have a dog in the fight. And that really conveys more clearly, I think, than I don't have a conflict of interest and you're the ones making the decision. People understand that much more clearly. And so one of the things I think we have to do is think about how we are communicating. The other thing I think it's interesting, we have to think very carefully about the language we're using. So for instance, if you use the word discovery, the lawyers are immediately thinking about when the interrogatories are due, when are we gonna have a deposition, you know, what are the letters rogatory, whatever the thing is, as opposed to changing that to what focused information do you need for your client to make an informed and voluntary settlement decision? And I think the language is important. And one other thing, when I give the opening statement, that is one of the most important parts of this process. And people have the tendency to skimp or skip it. And I don't think you should. You know, my wife, my kids, my lawyers, my staff don't listen to me. I know that by the way they act. But mediation parties and even lawyers listen to you because 3 hours later they may say, you know, you said, where is that? And so I had the one circumstance of a woman who had a sexual harassment claim. She had gone to the Bacchanal called League of Municipalities in Atlantic City and had been, her allegation was she had been physically molested by a mayor. And I thought I was so smart, and giving my opening remarks, I said, you know, this is not court process. Your remedies are much broader. I mean, where else could you get an apology? 3 hours later, she said, where's my apology? There wasn't going to be one. And I learned a hard lesson about what to communicate and how to communicate it.
Yeah, so I agree with Bob that the opening is critical. I actually talk about the Randy Kaiser studies and almost always in my opening. And people have thanked me very much for that. It's sort of because I'm telling them that your assessment, don't rely so heavily on your valuation assessment. I personally think that that is an area which creates a divergence, and we don't have a blue book like the car seller does, where you can say, oh yeah, but I have new tires and I have a new paint job, so you can add from the base. There's no standard, but there is a value that people are having to agree to about the prospect of this lawsuit. And so that's important to help them step back. I also think my personal emotion is engaged a lot of times as a mediator. And when I first started, I was very affected by aggressive lawyers who would say to me, you go in there and you get them to come down if you're a halfway decent mediator, you know? And it triggered me. It triggered me. It made me angry with that lawyer. So I was very much helped by some trainings by Doug Knoll, who talks about identifying emotions. And one of the very few things that can reduce the emotional level that's interfering with our cognitive ability is to identify the emotion. So now when that lawyer does that to me, I say, oh, you're feeling disrespected. And they immediately back, that might not be the right characterization. They'll say what they usually say is, oh, this isn't about me. This is about my client. And
you know, Laura, another way of dealing with when people come on very strong and want you to do something, they want to take control of the process, is I often ask, how do you think the other room's going to react to that? You know, and that takes them, they step back a little, and oftentimes they'll think about, yeah, maybe that's not effective. Maybe you go do what you think is the appropriate thing to do.
Yeah, well, you might not get as much bullying as I do, Bob.
You know, one of the things, Laura, that I've come to conclude is, and I've been surprised about, and I'm talking about with very high skilled lawyers who are representing clients in mediation, is how unstrategic most people are. They know how to put one foot in front of the other in preparing the litigation. We know they don't try the cases because, at least in New Jersey, the current statistics are 98.8% of all civil cases are dismissed or settled. So we know that there are very few trials. In fact, alternative dispute resolution may be the courts now, not us. But this whole idea of not being strategic is something that I think we can be very helpful in helping people strategize. And I think one of the other things we have to think about as mediators is, for instance, when do we go from a joint meeting to a caucus? Is it because we don't know what to do next, or have we thought about strategically why it makes sense? I know that's a lot of stuff to unpack.
No, but I really think that that's very important. The joint session, I think, has come under attack because it's too hard on most people. And emotions come out and then everybody wants to go away from each other. But that's an opportunity also. So I try and keep people together as long as I possibly can. Sometimes you can't really fight what the parties want, and that's self-determination too. But I think it can be very productive. I also think that when we separate and act as the go-between from caucus to caucus, the mediator bears much too much responsibility for accurately communicating, for not communicating the things that they ought not to communicate, and keeping things confidential that they haven't got permission to share. Even the temperature in the other room, I really wonder whether that, which you'll be asked over and over again, I really wonder whether that's, I have stopped answering that question. Then I say, I don't want to answer it for them and I won't answer it for you, because I think it's invading my commitment to keep confidential what you want to be kept confidential.
Yeah, but what I have found though is being as a mediator and being sort of supposed to be in control of the process or whatever that means, I have found that it's important to be upbeat, and it's important even if the other people aren't quite there to say, you know, they seem to be, you don't have to lie about it, but you might color it a little. They seem to be listening. They seem to be understanding. I've clearly made your points. I think one of the other things that I've done, and I've done this particularly in a technical area, for instance, if it's a sophisticated tax question or a scientific question, and I think it's important that I haven't picked up all the nuance. I may take the lawyers aside and let them communicate on those issues, not because it makes a difference who's right or who's wrong, but it then gets it off the table. One of the things I've also done in the joint session, because our culture is people are so conflict averse. You know, I always laugh. Someone might get they've gone to the trouble of paying a fee and brought a suit, and hiring lawyers and paying monies, or committing to pay monies on a contingent basis. And they say, gee, if we stay in this joint session with our client, they might get upset. They brought a damn suit. They're going to be upset for a long time.
They don't want to be exposed to it.
They don't want to be exposed to it. But one of the things that I found sometimes effective is saying at the end, is there anything else that you think is important to put on the table publicly before we separate? And especially I think in business cases, because the lawyers don't usually know the business. They certainly don't know the business the way the business people do. And I've had a number of occasions where the business people have really taken over, talked to each other, and solved the problem because they understand their business and what they can do that we as lawyers would not understand.
But that can also be a process issue. So in a very big mediation that I had recently, where there had been litigation and arbitration for 20 years, and one of the lawyers in the room told me he had only worked on matters relating to this set of issues in his entire career, and he was a young partner at the firm. I started out and got no receptivity. people leapt up and say, no, we can't do that. No, we can't do that. And I did this, and then I went in caucus, and they backed off of their own proposals that they had made. And then I said, well, maybe it's time for me to meet just with the business people. And I went in a room with the business people. They did bring their internal lawyers in. So it was a reduction from 25 people to 7. And we worked out a solution by the end of the day. And in part, that was because of a brilliant new CEO who was not involved in the original dispute.
But you have to be careful. I had a circumstance once where I got permission to meet with the parties without the lawyers. And one of the parties in the session, the private session with them, gave up a indemnification issue, went back to his or her lawyer, and the lawyer was furious. He didn't know, he didn't understand. So you just have to be careful.
Right, well, we had lawyers present in the room, and they were going out to consult with their outside counsel as well. So we didn't have any, anytime they got close to something they thought they were giving up, they would run around and talk to other people.
So I had an interesting experience the other day. I represent a client in an estate matter, and it's a brother who's 65 years old. His sister is 10 years younger, and they all grew up in an evangelical family. And so when they had the opportunity, and the lawyer for the other side's evangelical, so when they had the opportunity to pick either a experienced mediator who was a retired judge or a faith-based mediator, they of course picked the faith-based mediator. And it was an unusual experience because the faith-based mediator gave a 3 or 4 minute opening in front of the brother and the sister. The 2 lawyers in the room, their spouses, who were obviously a part of the problem, were excluded from the room. And I had to sit for 4 hours through a therapy session where the only people who spoke were the brother and the sister, who regurgitated their entire life, including a recent recognition of some sexual harassment, on and on and on and on. And at the end of the day, the other side, there were 2 issues. On one issue, they had to pray about it over the weekend. And the other issues, they said, we can't solve it because God told us not to do it. So, I mean, you find, and it was a good process in the sense that I think I'm going to be able to solve the part that they prayed about, because I came up with another angle. But it was an interesting joint session. The entire thing almost was a joint session, and without it, we never would have had the interchange of ideas. And I think one of the things we got to talk about a moment is, what is our goal in media? Is our goal to settle a case?
Well, and let me ask you that, because I have personally found that as soon as I let that go, the case resolves better. I
think I have changed over. I had been told originally that the goal was to settle cases. I think the goal is to help the parties communicate so that they're in a position to resolve their differences. But we also know how many cases resolve within the couple months after, and even they may be a year later, and it's on the same basis that the seed is planted in the mediation. That goes back to my do no harm instead of worrying about doing good.
Right. So I often tell the parties, this is your dispute. I can't resolve it. You have to resolve it. I'm here to help you, but I don't consider it a failure if you decide in your best judgment that you are better off going to trial. What I do consider a failure is if there is an overlap between you and we don't locate it during this time. And so that I do consider that my job, to try and help them find out if there is a place where they can meet. And there really ought to be, because frankly, the difference in the expense and the attorney's fees to going to trial ought to by itself give a lot of room for a settlement.
Well, one of the, I'm going to share a secret from the recently departed wonderful colleague of mine, Hal Braff. He would give a mediator's guarantee. You know, the lawyers don't give guarantees. So what's a mediator guarantee? His mediator guarantee is one of you's going to lose this case. And I very frankly think, and one thing that I found effective in helping communicate to people what their options are, is the concept of risk-benefit analysis. The idea that it's an engineering concept, we lawyers use it. The way I describe it, the problem in my case is when I use it, I have a tendency to overhype my side and devalue the other side. And, you know, so, and I use as an example, you all may remember the Oliver North hearings, where in Congress, a congressman asks a question, and Brendan Sullivan, a very high-level white-collar crime Williams and Connolly lawyer, had the audacity to say objection. And the congressman said, "You can't object, we're not in court." And he famously said, "What do you think I am, a potted plant?" So I described that in saying, I'm not a potted plant either, but you can't rely upon me for advice. I may be doing this as a devil's advocate, but let me help you, because I think if you look at who's doing the settling, it's mostly institutions. Institutions understand risk-benefit analysis.
But they don't necessarily do it well.
Well, let's talk about insurance companies for a moment. So if you don't pay people a lot of money to make decisions to dispense lots of money, you have to put safeguards in. You have to have accountability. And that's why they may have a rule that says we will not settle a case without an expert report or a doctor's report or some special analysis. And that's for accountability purpose. I can understand that. So instead of fighting it, sometimes it's easier to what can I do to help you facilitate getting that quickly and getting you back to the table?
I agree with that, Bob, but I also think that sometimes they're penny wise and pound foolish. So I had my first large tort mediation, and there were two insurance carriers for two of the defendants that really did have some potential liability. But we were early on, and actually that would have saved them a ton of money because we were early on in the process. And they were offering not even close to litigation costs. And we didn't get anywhere at the end of the day. And so this is a little bit of a switch between my facilitative and my evaluative hats. So as we're done, basically, and we're walking out the door, I say to the two people who are represented by insurers, you need to go back to your insurers and tell them they're making a mistake. You have some exposure here, and the amount that they are offering is just ridiculously low. And actually, that case settled the next day. So I don't know what happened. I don't know if they did that and that was the reason that it settled, or if the other party came up or whatever. But I do think that most mediators don't only have one hat. And even that during the course of the day, as facilitative as I want to be, I get more evaluative, especially if we're at impasse. I will try to make some suggestions, because at that point I feel like I'm only helping them.
Well, Laura, that's not your implicit bias. That's a little bit of your explicit bias. On the other hand, you know, and we all have to. I am not critical of anybody's style, because everybody has a different style, and I recognize, even though we teach and advocate, and the court rules talk about facilitative method. Particularly those of you who are lawyers have a tendency when you get frustrated, especially if you're a retired judge, often you'll have a tendency to go back to what you knew in the past and become you know, much more evaluative, and or the other word I think is directive. And the question is that is exactly what we're talking about in how manipulative. So let's talk for a minute about, is it appropriate to be manipulative under any circumstance? I have a short answer for that. The short answer, it's as long as the parties are signing off and aren't under any form of disability, and they've made a decision that this is in their best interest, to the extent that there's some manipulation in getting them to an end game, I am less concerned. Obviously, to the extent that they have a disability, that there is such a disparity in bargaining power, that then, you know, I wouldn't push, you know, as hard. But we recognize that people come in all stripes. They're good lawyers and bad lawyers. They're smart clients and stupid clients. It's not up to us to solve, it's up to us to present the opportunity to solve their problem, but it's not up to us to solve their problem, because we have a tendency to solve their problem as we would, and we don't have to live with the result.
And so you don't try to level the playing field, as they say.
Well, let me give you an example of how I might level the playing field. If a lawyer comes in with a particular, whether it's a case or an analysis that, based upon my knowledge, I know is wrong or unlikely to prevail, and they haven't appreciated the extent to which it's unlikely to prevail, I may do what Judge Dreyer, you know, a terrific, you know, MIT, Columbia-trained judge might do, is he, as a national expert, would take the lawyer sort of like a Dutch uncle into the library and said, when I'm in the other room, you may want to look at these couple cases. He'd pull some cases off. Now, he is much more evaluative and has much more breadth in the law than, you know, than we do, just because of, you know, his experience and all. On the other hand, I think I look at this as information. To the extent that you're bringing people information that they otherwise wouldn't have for them to evaluate. But people do end up resolving their cases if they have the opportunity to do so. And I think one of the things that we do in controlling the process is keeping the temperature low enough and the information high enough so people can rationalize or justify the decision they're making. Because
I also think that some of the information is about diet, having people be well fed so their brain can work. And some of it is about your relationship with them. I used to not want to give anybody, as a young woman lawyer, I never wanted to serve coffee. That seemed to me to be a recipe for disaster for many years, until I read a study that said, if I were going to hand somebody something warm, they will think of me as warm. I now regularly give out something warm at my mediations, because I think it does. It's odd, but it has a psychological impact. So, you know, that is probably manipulative.
Well, yeah, I'm not sure it's inappropriately manipulative, but it probably is. There's a lawyer, there's a mediator, a woman mediator in Florida. Rick Steen and I years ago went to the Florida meeting, and we heard these very high-level mediators. She had a mediation center, and she did a couple of things. One thing is, someone would come in, she'd go greet them. Hi, I'm Mary Lou, I'm your mediator. I think she left her resume out so it was easily you know, available so someone could read it. I know when I go into an office and I see diplomas on the wall, I read them to see, you know, so if you have an award or something, you know, maybe, you know, stick it on the wall. It's all about that trust and confidence. We don't have the robes, we don't have a flag, we don't have a raised platform, we don't have a court officer there. So we've got to figure another way. And another thing that this woman did is she always had cookies. You know, you don't go into a courtroom, the judge doesn't give you cookies. So part of it is this warm feeling you're talking about. Part of it is this experience is going to be a different experience. So for instance, you note that I didn't wear a suit and tie today. And maybe I wouldn't wear a rugby shirt to a mediation, but I would wear a shirt and a sweater, you know, to demonstrate I'm not the judge and I'm not going to be acting like the judge. Who's going to be making your decision. I don't need that formality because you're making the decision. I'm just going to help you get there.
So Bob, let's make sure we covered all the topics that you wanted to cover today. You also talked a little bit about the law when you talked about Judge Dreyer and how you bring the law to the parties. In the understanding-based approach to law, they bring a neutral person to talk about the law in a sort of neutral way. So that's another alternative if there's a critical issue. But there's also sort of process solutions that might arise. I had a dispute between a seller and a buyer of a business, and all kinds of claims kept arising. So basically the buyer had bought a liability rather than a good business. And they had a dispute about how to solve all those. The seller was saying, well, but she's just settling those, paying people off, and their claims are terrible. And so we agreed on an arbitrator that they agreed to, a professional who they both liked, who was going to deal with those disputes. So sometimes there's a solution that might be a process solution.
Well, let me give you an example of something I had. There was a particular witness, and he was at the mediation, and they had not had depositions, and the dispute was relying upon what this person was going to say. So we worked out that in the presence of everybody, I would do the questioning of the witness. It would not be a confrontational questioning, and they would then hear and the witness happened to be a terrific witness, came on very, very strong. They went in the other room without me and settled the case. So I mean, these ideas of, this concept, and we talked thinking out of the box, what are the kinds of process things that we can do? And let me give you another example. I've had a circumstance where it turned out the lawyers weren't prepared, surprise, surprise. They brought their clients there, and the value of some property was at issue. And I said, well, why don't we, for purposes of discussion, not reliability, why don't we go on Zillow or one of those sites and see what that says? And that at least gave context to be able to have the discussion. And frankly, every time I've done that, the case settled. They didn't need to have the appraisal or anything, because they were generally aware of what the value was under any circumstance. So there are lots of different things that you can do. This whole idea of the objective reality of going out and finding standards, since we have the world's knowledge at our fingertips today, often you can Google something and come up with an answer. But be very careful. It's not your answer. The people have to buy into it as their answer. They're relying on it. And you're not the one giving that as advice, and they should rely on, I oftentimes say, you're not relying on me to make a decision. You're relying on your advisors and yourself in making this decision. And I don't want you to think that I'm coming up with the answer. Having said that, how many times do we come up, whether it's an option, whether it's a mediator number, whatever device we use in impasse breaking that makes a difference, so my two questions for today: is that manipulative, and is that a bad idea?
Well, it's hard to know. I had another case where process solution worked, which was a case where confidentiality was very important. There were two related or similar cases, and the defendant didn't want to resolve this one because it would impact the other one. And it was a court case. So I said, well, if you take this out of the court process and enter an award in arbitration, if you pay, they won't have any reason to enforce it. And, it will never, you can require it retains confidentiality as part of the settlement agreement between you. And they did that, and it was a very good solution because they were able to then negotiate that particular case as opposed to the other case as well. Well,
and why don't you, so people may not know, you can do in arbitration a consent award.
Right.
So, and that consent award is otherwise enforceable, but if they pay it, then,
right. Then you'll never have
off the docket, so to speak.
Right. You'd never even have to have the information about it available, even the fact of a settlement.
Yeah, well, that's a subject for another time, but the other pillar, and I got these from Hannon Isaacs, the two pillars he talks about are self-determination And under the standard, the fifth one, confidentiality. Confidentiality can be so helpful.
Okay, so I do have a question. How effective are these tools being facilitative, manipulative, or even directive in a fully telephonic hearing?
Well, that's it. I've done the Skype before. One of the things I think I have to do is get better at it, because you have to be very careful that you don't spill over from one side to the other side when you do it. I think it's, without the human contact, it's very much more difficult to translate. And that's for a lot of different reasons. One of the reasons that it's not a good idea for a baby to learn about everything on television is you don't get the micro impressions that your face makes. Those don't come through on a television. And so it's the same thing as we communicate. Much of our communication is, nonverbal, and we don't even recognize it. So that makes it more difficult to gain that trust.
So do you think that trying to help the parties, either by reality testing or any other form of cognitive improvement, is more difficult over the telephone?
But I think if the party, look, we know a couple things. We know if the parties want to resolve it, it's much easier. We also know there are studies that say that being forced into mediation or volunteering, there's no difference in resolution rate. So I take the circumstances as they come. So if something goes awry, the right person doesn't show up, we do our best to give people the opportunity under whatever the circumstances are. And
I would say that I would prefer Zoom or Skype to the telephone exclusively. I think telephone is a really hard circumstance, but increasingly we're going to have mediation online. I think that's just the fact.
No question. And if you're interested, if you look up Colin Rule and see what he's doing with the various companies that he's been with, he designed the PayPal and
eBay.
Which one?
eBay.
eBay resolution devices. So very exciting stuff happening.
So I think we're almost toward the end of our presentation. If anyone else has a question, please ask it now, and we will try to answer it. I want to thank Bob very much for his insight into this and for this whole question, because all of the things that we're studying scientifically about judgment, and also neuro-linguistic programming and how we use language, how we help the parties, what we do, very important for us to be conscious of. The judgment studies that we talked about a little bit in terms of cognitive and implicit bias, they're actually pretty old, but lawyers are pretty far behind the understanding. I mean, you have Kahneman, who received a Nobel Prize for this studies in judgment science. So we know that there are things that we need to better study to help us either be manipulative or not be manipulative, but understand what we're doing.
I think as long as you understand, know thyself, and are cognizant of the Hippocratic Oath of doing no harm, you'll do much better. And the idea of letting go makes sense.
Okay, the study of the authors, I have one remaining question on decision error, is Randall Kaiser, K-I-S-E-R, and his book is called Beyond Right and Wrong. And every law firm really ought to have that book, because it also breaks it down by case and case type. And Carl, are you going to say goodbye for us?
I am. I want to thank you very much. It was really very good from both of you. And thank you again for making another NJAPM webinar memorable. Our next webinar will be next month. I'll be sending out a notice soon, and it will be on social media. So I'll look forward to seeing many of you again, I hope. So thank you very much.
Thank you, Carl.
All right.
And thank you, Laura. It was a good time.
Bob, it's always great to talk to you. Thank you.